So now we're going to talk about evidence, which if you remember at the beginning of the intro, I talked about how trials are made up of evidence and argument. So evidence is the dots and argument is the story. So we're going to talk now about evidence, which is made up of witness testimony and exhibits. So that's the majority of what mock trial is all about. So let's get into it. So witness examination is going to be the bulk of your mock trial. Witnesses are put on the stand to testify and they are asked questions by the attorneys. So there's two different types of questioning. There's direct examination, which is when it's your own witness and they're friendly to your side of the case. And then there's cross-examination, which is when it's not your witness and they're hostile to your side of the case. So those two types of questioning are going to have different variations to them. And when we talk about who's the star of the questioning, it's going to differ depending on if it's direct examination or cross-examination. So the first thing that's going to happen is direct examination when it's your own friendly witness. And on direct examination, the witness really should be the star because the attorney is asking open-ended questions to allow the witness to really tell their story. They have the important information to get in, so the witness is the star on direct examination. So when you're on direct examination, there is a very specific way to ask questions that differs from when you're on cross-examination. So when you're doing direct, as I said, witnesses can only answer questions that you ask. So you want to make sure that you're not leading the witness on here because you want to give them time to elaborate on their answers. So leading the witness is when you sort of direct them to an answer, and we'll get to that because you do that on cross. But on direct, you don't want to lead the witness to the answer. The witness is the star, so you want to have open-ended questions that allow them to narrate a little bit about their experience. So for example, if you are asking about a specific night, so you went to the food truck at around 8 p.m. Can you tell me about that chain of events? And that is an open-ended question where you allow them to elaborate. And the witnesses, while they're allowed to elaborate, they have to answer the question directly. So they can't go off on just totally narrating their entire witness statement. It has to be tailored to the question you answer or you ask them. So if it's about the food truck, they have to limit it to just that scope of time and just that question. And it's also helpful for the judge when they do that because you're kind of laying those breadcrumbs for the judge to pick up on. And the timing is a little bit different for high school and middle school because high school, we give a set amount of time for all of direct examination. So we give you 20 minutes for both of your witnesses, and you have to decide how to divide up that time. Your team will have to decide. For middle school, we give the amount of time per witness. So middle school, each direct examination of each witness is a maximum of 6 minutes. For high school, it's 20 minutes for both witnesses, and you have to decide how to split up that time. So if you have a witness, your team is calling a witness that has a lot of information or really complex information that's going to take a lot of time, they may want to take up more of that 20 minutes than the other witness who maybe is a little more straightforward. So it's a certain strategy that your team will have to work out just depending on the witness statements they're working with. Okay, so now that we've covered direct examination and generally how you want to approach it, I have a tutorial video where we had a team come in and show how you do direct examination. So we'll watch that now.
The defense calls Jesse Springfield to the stand. Could you please introduce yourself to the court?
My name is Jesse Springfield. I'm 17 and I'm a junior at Phillips High School.
Why are you here today?
I'm representing 5 of the members of Occupy whose voices are being silenced by the school.
Could you tell us what Occupy is?
We're a group of students that are protesting for our constitutional rights to have a say in our school and its decisions. It's a beautiful thing, really. We're taking what we learn outside the classroom and actually putting them to practice.
Did Principal Gomez give Occupy a time, place, and manner for its protest?
No, she only told us that we couldn't protest, which of course wasn't an option.
So does that mean that you stopped protesting?
Of course not. We still needed our voices to be heard. So we had an emergency meeting that night outside the football stadium.
What happened at that meeting?
At that meeting, we came up with this idea called Tent City. And it was really exciting. I thought we could do something great for the community.
What's Tent City?
It's an occupation of Freedom Field. Well, it's more symbolic because we weren't actually on the field, but it was still pretty cool. And we posted signs protesting the NFC deal, which hopefully some of them got the community's attention.
Speaking of the community, who came to Tent City?
A bunch of people, reporters and people who supported us and parents and our history teacher, Mr. Chen. And a few cops walked through at some point taking pictures, but they didn't talk to us.
Was it your intention for Tent City to disrupt NFC's construction?
Our intention wasn't to physically stop the construction because it was a symbolic protest. Our intention was just to get the school to notice us and understand that students deserve a say in things that affect them like this.
So did Occupy block entrance to the football field?
No, we did not.
Did Occupy vandalize any of NFC's equipment?
Of course not. That would go against Occupy's core values.
What was the atmosphere of Tent City like?
It was really exciting, and it was also pretty laid back because everyone was just hanging out and doing their homework and making signs.
Finally, was Occupy disruptive to education at Phillips High School?
Objection and proper expert opinion.
May I respond, Your Honor?
You may.
This question doesn't call for expert testimony. I'm simply asking the witness about her perceptions of education at Phillips High School.
Your Honor, may I respond?
You may.
Your Honor, this is asking for expert testimony because as to whether the education was actually disrupted, it goes to Tinker v. Des Moines.
Objection sustained.
Was your education disrupted by Occupy?
Not at all. If anything, it was the opposite. So much debate and discussion came up from this deal, and it was really exciting to actually take what we were learning in our class and apply it to our lives.
Thank you, Your Honor. No further questions.
Okay, so now that we've covered direct, we're going to cover cross-examination. So as I mentioned, cross-examination is different because the witness on the stand is not friendly to your side of the case. They're not your witness, it's your opponent's witness. So these witnesses were originally called by the other side. They've already been direct examined by their own attorneys, and now it's your turn to have your team ask questions of this witness that's a little bit hostile to your side of the case. So it's your chance to do a couple of things. This is sort of your goal on cross-examination. You want to discredit the witness's testimony. So if you can make points that show that this witness is unreliable, that's the time to do it on cross-examination. Because if they are unreliable, then it doesn't really matter what they testify to if the judge can't believe that it's true. It also allows you an opportunity to introduce doubt into the case. So if this witness has some information that is different than the theory the opponent is trying to present, you can really highlight those things to introduce doubt to your opponent's case. And then if this witness has any facts that are friendly to your side, your opponent is going to want to have downplayed those or not address them at all. On cross-examination, it's your time to really highlight the things that this witness has that can help your side of the case. So as I mentioned earlier, questions on cross-examination should be leading. So you cannot ask leading questions on direct examination, but that is the way you should approach cross-examination. And the reason is you really want to narrow what your witness is allowed to talk about when it's cross-examination. Since they are hostile to your side of the case, you don't want to give them time to elaborate. So leading questions are things that sort of point them to the answer. So an example is, you were in the barn when the cows got out, correct? So that's really a yes or no. It's not, tell me what happened when the cows got out. That would be an open-ended question, and you don't want to do that on cross. You really want to point them to the answer. So you were there when this happened, correct? And then it kind of forces them to answer in a yes or no way, or something similar to that their answer is really narrow. And it's important to remember for high school, even though you have 3 witness statements on each side of the case, only 2 witnesses are called, but you don't know which witnesses are going to be called until right before the trial begins. So your team has to be prepared to cross-examine all 3 witnesses because you won't find out until you get the score sheet from your opponent. So it's really important that you're practicing cross-examination of everyone. And the timing here, just like it was for direct, it's different for high school and middle school. Middle school, we give you the time per witness, so it's 4 minutes of cross-examination per witness. That's the maximum amount of time. For high school, it's 18 minutes of cross-examination that you have to decide how to use that across both witnesses. So just like you did with direct, you're going to have to manage your time. You get 18 minutes for cross, and you have to figure out how you want to split that up. So we have a video, just like we did for direct, that's going to show you, it's a tutorial video of how to approach cross-examination questions.
let's talk about why you're here today. You and 4 other Occupy members' lockers were searched, correct?
That's correct.
And so were your backpacks, right?
Yes,
Now, you say this was without your consent, correct?
it was.
You are familiar with the Phillips High School Student Handbook, right?
I believe so.
Your Honor, let the record reflect that I'm showing opposing counsel a clean and unmarked copy of Exhibit A. May I approach the witness?
You may.
This is select provisions of the Phillips High School Student Handbook, correct?
Yes.
Please read along silently as I read the second paragraph under search of a student's personal property by school authorities. The principal or her designee may search your backpack or purse without your consent or your parents' consent if they have a reasonable suspicion that you're breaking the law or violating a school rule. Did I read that correctly?
You did.
Now, let's talk about why your locker was searched. Your locker contained Occupy flyers, right?
Because we weren't allowed to hang them up anymore, yes.
But you had been hanging these flyers up all around the school, right?
Before we weren't allowed to anymore, yes.
But you knew before you hung them up that they were violating school rules, right?
The flyers themselves weren't violating school rules, no.
But you knew that you had to get them approved by the principal one day in advance, didn't you?
We did.
And you didn't do that, correct?
In order to avoid censorship of our flyers, yes.
So you purposely didn't do that, right?
To avoid censorship, yes.
So you broke that school rule, correct?
That one minor school rule, yes.
Now, the flyers did not have an individual student's name on them, correct?
It was unnecessary, no.
Occupy meets on school property, right?
We met a few times in unused classrooms, yes.
In order to organize protest, Occupy meets in the school cafeteria, right?
A few of us have lunch together, yes.
And this is during school hours, right?
Yes.
Occupy wasn't approved by the principal, was it?
No, we were not.
Occupy isn't registered as a student group, is it?
No.
In fact, Occupy didn't even attempt to register, right?
No, we did not.
Now, you would agree that you wanted your protests in the school to move forward, right?
Well, of course, yes.
And you want them to move forward even if they break school rules, right?
I care more about the Constitution and my rights than a few minor school rules, yes.
So that's a yes?
Yes.
No further questions.
Okay, so now that we've seen how the initial direct and the initial cross-examination work, we're going to talk about something called redirect. So this is all coming from the same pool of time for high school that we talked about earlier. But after a witness has gone on the stand and you've given your direct examination and they've been cross-examined by opposing counsel, there is the opportunity for your team to redirect examine this witness. So the same attorney who did the direct examination of this witness can ask them some more questions after cross-examination. So this really gives you the chance to have this witness repaired. So if they suffered some things on the stand during cross-examination, if they came across as a little bit unreliable, or just the information they were giving wasn't as clear as you wanted it to be, this is your chance to rehabilitate the witness. So your attorney can go back and ask them questions. The caveat to that is this is not a time for you to ask questions that you just forgot on direct examination, because it's limited to the scope of what was asked on cross-examination. So if it didn't come up on cross, you can't ask about it on redirect. But if they ask some questions on cross-examination and you really want to shore up that point, you can hit those questions based on what the cross-examiner asked them. This is optional and it can only happen once, so there's no redirect. But it depends on how the witness held up during cross-examination. If there's some things you want to rehabilitate, that certainly may be worth it for you to use this redirect time. But just know that if you do redirect, you are opening that witness up to re-cross-examination. So if they had a really rough cross-examination and you're not sure you want the attorney to have another chance to cross-examine them, it may be wise to skip redirect. So there's a lot of strategy that comes into play here, and you just have to figure out with your witnesses and your attorneys what would be the best approach. So as I just mentioned, if you do redirect, you allow recross. So after the witness has been directed, cross-examined, redirected, opposing counsel can decide if they want to ask or have recross, where they get another chance to cross-examine. So it's really your opponent's time to reintroduce doubt. So you've shored up some things on redirect. Now they can reintroduce that doubt and they can ask questions, but it can only be based on the questions you asked during redirect. So you can think of witness examination as a funnel. So it starts out really wide, and as each one goes, it narrows down. So you've asked questions on direct and cross, and then you have redirect, it's really narrowing the scope, and then recross narrows it even more. Okay, so we've covered all of the witness examination. That's the big part of your evidence. That's going to be the bulk of the evidence in mock trial. But there are also exhibits. So this is an example of an exhibit from a past mock trial case. So this is the 2018 case, Adam Smith, which was based on that Serial podcast about Adnan Syed. So this is an example. It was a tower proximity report. So cell phone data and connections pinging off of those towers played a really big part in the case. So this was an exhibit that they could use during the case. So how we approach exhibits, it depends on the exhibits given, but they can only introduce them based on witness testimony. So you can't just bring in an exhibit when you feel like it. You have to introduce it in some way so that it makes sense, so it's not out of the blue. So while all exhibits in mock trial are stipulated as admitted, so you don't have to prove to the court that they're accurate in order to admit them to the court. You don't have to worry about that. You just have to have your witness, if you're going to ask your witness to testify about an exhibit, they have to show some personal knowledge. They have to have a reason to testify to this exhibit. So something like, you've lived in Trillium your whole life, correct? Yes, okay. Would you be familiar with a map of Trillium around the high school? Yes, I would. So then you can move to have the witness talk about that exhibit. So something else to keep in mind for exhibits, this is really important for the trial. When you present an exhibit at trial, it has to be a clean and unmarked copy. So OCLRE in the mock trial materials gives you all of the exhibits in black and white, and it's on 8.5 by 11 sheets of paper, and that is the way that it has to show up at trial. So you cannot enlarge any exhibits, you can't turn them into color or anything like that. And then when you actually use it at trial, it cannot be marked up or laminated or anything like that. So there can't be any highlights, there can't be any comments. And so whenever you go to introduce an exhibit during trial, the attorney should show the judge and opposing counsel the exhibit that you're referencing so they can see that it is in fact clean and unmarked. So that's really important to remember going into this and preparing. And you'll also want to have copies of that. So if you're planning to use these exhibits at trial, if your attorney wants to reference it, they should have a copy that they can pull up, which means you probably want to make a copy separate from the actual case material so they can just pull up that one piece of paper. Okay, so now that we've talked about all of the evidence and what it actually is, so we have our witness testimony and our exhibits, we're going to talk about the rules that govern all of that evidence. So we'll get into some of the specifics. We have given the mock trial participants a very simplified version of the rules of evidence just to make it more manageable. If we gave them the full thing, it would be much too long for them to go through and reasonably use. And we model these off of the Ohio rules of evidence, but just know that you're limited just to the information that OCLRE provides in the mock trial case. So like we talked about in the beginning and the why we have a trial the way that we do, let's talk about why we have the rules the way that we do. So our adversarial process is to get to this truest truth and allow in reliable information. Our rules of evidence are there to make sure that we're doing that. So the rules of evidence make sure that we're only allowing reliable testimony and reliable information to come into the trial, and we're going to suppress or keep out unreliable information. So when we talk about hearsay, that's one of the rules that we're going to go over. Why is hearsay inadmissible? Well, you can't prove how true or untrue something is if that person that said the comment is not in court to testify to it. So because we can't rely on the truth of that statement, we're not going to let it into the trial. And just as I mentioned, the rules govern all of the evidence. So the rules covered the physical exhibits and the witness testimony. Okay, so now that we've talked about the evidence and why we have rules of evidence to govern the testimony and exhibits in mock trial, I'm going to go over some common examples of things that come up a lot in mock trial. So on the screen you'll see some major rules of evidence, and I'm going to go through just really quickly what these mean. I don't want to go too in depth because the rules of evidence you really have to take some time with for yourself and with your students to understand them more in depth. So I'm just going to give you an introductory explanation of what some of these important ones are. So starting with rules 401 and 402, it's the definition of relevance and then how that relates to mock trial. So relevant evidence is evidence that the attorney is using to show that a fact of consequence to the outcome is more or less probable. And so it has to be a fact of consequence to the outcome. That's really important. And the testimony has to show that it's more or less probable. If testimony is unrelated to the facts at issue in the case, it's irrelevant and opposing counsel can and should object to that. So irrelevant evidence is not admissible, so that is objectionable. So moving on to Rule 602, lack of personal knowledge. So this is fairly straightforward in the information that it already provides, but witnesses can only testify about things which they have personal knowledge, so things that they saw or experienced or personally perceived. There are some exceptions to this, but the general rule is that people can only testify things about which they have personal knowledge. So we already kind of mentioned that with the exhibits, but that relates to every testimony. So looking at Rule 611C, this is just about the format of direct examination, how you ask questions on direct. So refer back to my explanation of direct examination and how you cannot ask leading questions on direct examination. Rule 701, opinion testimony by lay witnesses. So lay witnesses are non-experts, and they're very limited to the kinds of opinions that they can give on the stand. So this rule will lay out the form that those opinions have to take for it to be allowed. Rule 801 and 802 and 803 and 804 all cover hearsay, so it's going to cover the definition of hearsay and then the exceptions to hearsay. So hearsay itself is pretty complicated, and it's one that you'll have to spend a lot of time working with. So we do have other videos that go over hearsay in more depth, but I'm going to just give you a quick overview. So as an introductory point, hearsay is an out-of-court statement made by someone other than the witness that is being offered in court today to prove that the content of the statement is true. So that last part is really important. So we do have other videos that are going to explain that whole thing. Truth of the matter asserted is a big one. Generally, hearsay is inadmissible, but there are some exceptions to hearsay, which I will go over next. So hearsay exceptions, these are allowed because they generally are more likely to be true. So statements that follow these exceptions are more likely to be reliable. So an example is a prior statement given under oath. When you're under oath, you've sworn to tell the truth, so therefore that testimony is more likely to be reliable. Present sense impression is when you're in the moment and something is happening, you're more likely to be truthful about what is actively happening, so it's allowed in court. Excited utterance is something that just happens on the spur of the moment because it's startling, and so you just kind of exclaim something almost involuntarily, and when you're exclaiming something like that, you're very unlikely to lie about it because you're just sort of involuntarily providing that information, so that makes it more likely to be true. Statement for medical diagnosis or treatment. So people, generally speaking, don't lie to their doctors when they're seeking treatment or they need medical diagnosis. So when they're giving statements for the purpose of seeking medical treatment and diagnosis, they're trying not to lie to their doctors so they can get the medical care that they need. So those statements are generally more likely to be true. And then belief of impending death. So this is the classic deathbed confession. When death is impending, they want to unburden themselves of all of the secrets they've been keeping from their family and friends. So that's where they're going to tell them things that they just really need to get off their chest. The important thing to note in this one is the belief of impending death. So it doesn't mean that they actually have to pass away. They just have to, at the time they made those statements, really believe that they were going to die. So because you're very unlikely in that moment to lie, since you're just trying to unburden yourself, those statements are more reliably true. All right, so that was a really quick overview. As I said, you're going to want to spend a lot of time with the rules of evidence and make sure your students do as well, because they're going to need to reference those in trial, not just to make objections, but also to respond to objections. So I'm going to go over some rules of evidence that are unique to mock trial. So mock trial is certainly not the same as a real court in the sense that it's a very confined world. So we have some rules that are unique, mainly invention of fact. So invention of fact is when a witness would make up something that's not in their witness statement. So on direct examination, the witness is absolutely limited to the information in their witness statement. They cannot elaborate, they can't make up any new facts. What's in their witness statement is what they can testify to. So there's no invention of fact permitted on direct. On cross-examination, they are allowed invention of fact in very limited situations. So if on cross-examination, an attorney asks the witness a question and they can't answer it only with the information in their witness statement. So if they've asked them a question about their education, for example, and the witness statement doesn't mention anything about their education, we're not going to make the witness just say, I don't know, because that's not fair. The witness would reasonably know their own education. So they're allowed to respond with what education they have, but they have to be really narrow. They can't just go off and make this crazy elaborate response. It has to be only enough to answer the question the attorney asked. So they can say that they went to Harvard and got their undergraduate degree. They cannot go on to say, oh, and then I got my master's at MIT, and then I went and did my medical residency here, and elaborate all of these extra layers. That's way more than is necessary to the question that was asked. So make sure you actually read the text of the invention of fact rules and work on those with your students. Okay, so now that we have a general understanding of the rules of evidence, let's talk about how you actually make objections, because that's where these rules of evidence come into play. So generally speaking, this is how an objection happens. Objectionable testimony or attorney conduct happens, so something objectionable happens. Opposing counsel will stand and say, objection, Your Honor, or I object. They will state the grounds for their objection. Sometimes the presiding judge may have just already asked you, please state your grounds, so let the presiding judge kind of take your cue there. Give the grounds, so that's where you're going to reference the rule that has been violated. So objection, Your Honor, relevance, or objection, Your Honor, lack of personal knowledge. The presiding judge will declare the objection is either overruled or sustained. If it's overruled, that means you're allowed to the person is allowed to continue on with that questioning or that conduct. If it's sustained, that questioning or conduct is no longer allowed to continue. So we have a video here that goes over the evidence rules and objections. So you're going to see the attorney give some question to the witness, you'll see an objection, and then how things unfold after that.
Finally, was Occupy disruptive to education at Phillips High School?
Objection and proper expert opinion.
May I respond, Your Honor?
You may.
This question doesn't call for expert testimony. I'm simply asking the witness about her perceptions of education at Phillips High School.
Your Honor, may I respond?
You may.
Your Honor, this is asking for expert testimony because as to whether the education was actually disrupted, it goes to Tinker v. Des Moines.
Objection sustained.
Was your education disrupted by Occupy?
Not at all. If anything, it was the opposite. So much debate and discussion came up from this deal, and it was really exciting to actually take what we were learning in our class and apply it to our lives.
Thank you, Your Honor. No further questions.